Welcome to Mindscapes, our series of conversations with men and women whose ideas, visions and philosophy define our contemporary world. My guest today is a recent Chief Justice of India and currently Chairman of the National Human Rights Commission. I'm delighted to welcome Justice Verma.
Thank you.
So what is the difference between, the law is meant to mete out justice. What is the difference between law and justice?
Well,
Frequently it's confused, isn't it?
yes, you are right. Law is really justice is institutionalized morality, if I may say so. And therefore, law should, as far as possible, be equated with justice, because justice is required to be done in accordance with law. That is what the instrument of law is meant for. Now, if that is so, then ordinarily they must be equal. But in reality, what you find is that there is usually a gap. The reason for the gap is that the law, when enacted, cannot take into account all possible future situations when that law would require application. So when that occasion to apply arises, then you have to see where really does the justice lie, and to the extent law may fall deficient, well, that's where the judge's creativity and very much his perception matters. And I would put it like this. Mathematically stated, law plus X, which is the element of morality or ethics, is equal to justice. Now this X, the effort should be in the judicial process to reduce it as far as possible, preferably to zero, so that law is equated with justice.
Have there been, in your sort of very long and distinguished career, have there been moments when you have felt frustrated with the law?
Well, I wouldn't recall a single incident when I felt frustrated, because I thought my purpose of being where I was to read law in a manner so that it could find a just solution to the problem. And I don't recall a single occasion when I couldn't.
You also mentioned this aspect of morality, and in some measure the law embodying social morality, shall we say, or what are socially acceptable morals. But in a rapidly changing world where there are changing notions of morality, we seem so often stuck with the archaic and the irrelevant, in a sense.
I would put it like this. You see, that is where the perception of the judge really counts. And the perception does not develop overnight, or it does not start developing when you are faced with the problem. It is the kind of environment you have grown. It is the kind of values which you have imbibed while growing up, which really color your perception. And a judge's perception depends on what he has. You see, everyone gets the same input. The only thing is whether your antenna is properly attuned to receive and absorb that which is correct. And you must have heard of people talk of judge's philosophy. This is what I personally understand by judge's philosophy. That's the reason this very same statute or provision in a statute, sometimes you find people, different judges, all you see equally competent, all equally trained, you see they view things differently. That difference is accounted for the manner in which you look at it.
So could you give us sort of an example where you feel you sort of most creatively engaged with this?
Well, that's a difficult question, and I think it's someone else who has to answer it. But let me tell you, the thing which gives me satisfaction even today is the development of that judicial process, which has now been accepted in legal phraseology as continuing mandamus. Now, everyone is aware of mandamus, where the court in a writ petition gives a direction for compliance. Very often what used to happen was a mandamus was given to a person who had failed to perform a legal obligation to do it. And then when he did not, then a contempt petition would come. That was the indirect way. Well, what occurred to me as the presiding judge, with which my colleagues on the bench fully agreed, you see, when I discussed with them, was this, that if we combine the process in one proceeding and call it monitoring, so that we give the directive to perform and retain seisin over the matter till the completion of the performance is reported. You see, we would be thereby giving a mandamus which would be continuing till the performance is made. Now, that people think is an advancement and or a new tool forged in the judicial process, which incidentally has received worldwide acceptance.
You've been a part of a distinguished lineage, hierarchy perhaps, of Chief Justice of the Supreme Court who have continued a sort of an activist judiciary. And recently we've had this debate on rewriting the Constitution, and one of the sort of purported aspects that they want to look at is judicial activism.
Well, I personally feel there is nothing which anyone can do by amending any law, you see, so far as this part is concerned. Well, let me, you see, enter a caveat. Judicial activism is very often used in a very pejorative sense. That's not what I understand that to mean. And since people seem to identify me to a great extent with that process in the 90s, therefore I think I owe an explanation to the people, let them, which I have had occasion to say in many of my speeches. Actually, I was invited to inaugurate the Law Asia Conference in Manila, Philippines in 1997 when I was Chief Justice, and the topic which they gave to me on which I was to speak was judicial activism in an Asian democracy, for certain very obvious reasons. Now, what I emphasize there, which I have done on other occasions before and after also, you see, every decision which is made in the judicial process, you see, should have some juristic base, so that either it is based on a pre-existing legal principle, or you have evolved a new legal principle which has solid jurisprudential base, so that it has precedent value. It is not an ad hoc decision for a particular case. It has precedent value to be applied in similar situations in the future also. And if that is there, it is within the legitimate bounds of judicial review. Actually, I mean, if you may recall, judicial review itself is the result of so-called judicial activism. See, this judicial review, when Marshall pronounced, Chief Justice Marshall of United States Supreme Court, you see, propounded that theory in 1803 in Marshall versus Marbury versus Madison. Well, other wings took umbrage. They thought they was doing something which was unheard of, and he was trying to encroach on other fields when he said that whether a law is constitutional or not, it is for the courts to decide, and what the law is for the court to decide. But it would be interesting to also know that 2 centuries before that, Lord Coke in England, in Dr. Bonham's case, 1608, had said the very same thing. But then so judicial review itself is the evolution of judicial creativity. And now at least no one can doubt it, at least in our country or even anywhere in the world in a democracy. You see, judicial review is a basic feature of the Constitution.
But there is a distinction between the idea of judicial review and judicial activism, should we say?
I wouldn't agree to that. The so-called judicial activism is within what is called judicial review, because it is in the process of performing the act of judicial review. What is done is termed as judicial activism, and that is why I said, if it has a juristic base, if it has precedent value, it's not an ad hoc decision. Then you see.
But what happens, for example, when the court says that you should follow certain pollution levels, say in a city like Delhi?
Yes.
Where is the distinction here between review and activism?
See, I mean, I think that's a very good question. I mean, I'm glad, let me tell you, because I was involved in that
That's
also
right.
to a great extent. You see, the Supreme Court had already construed Article 21 to mean right to life with dignity. Now, everything which is required for a dignified life, and I'm sure good health is one. See, education, proper nutrition, and health care, these must necessarily form a part of life with dignity. If that is so, anything which is a negative factor to achieve that end, is a violation of Article 21. If it is a violation of Article 21, then it is violation of a fundamental right which is enforceable under Article 32 before the Supreme Court in an original proceeding. And in exercise of that power under Article 32, which I have always understood to mean constitutional obligation of the Supreme Court, not the power of the Supreme Court. There is a difference between obligation and power. And therefore, when there is large amount of pollution, so that the environment gets polluted, the right to development, which is basic for every child, you see, that is endangered. Then naturally the Supreme Court must step in. The violation of human rights is of the entire people, not merely of an individual or a few people. And Supreme Court has been given that power under Article 32, therefore it must be exercised when the magnitude of violation is so great, particularly when the framers of the Constitution were not satisfied merely with giving 32, power under 32. They also provided in Article 142 that whatever is required to be done in a given case for giving a just decision in the cause, that also, that kind of order also can be made by Supreme Court. Now you read 32 with 142, and then 144 says it is the duty of every civil and judicial authority to act in aid of the Supreme Court. Now I think these powers are very wide.
But that begins to suggest that there are virtually no limits. But what is this circumscribed by? What are the limits of...
I'll tell you the limit. In none of these cases, we performed the act which was required to be done ourselves. We combined these powers to mandate the concerned authorities to perform it. So that now all this is based on a solid legal juristic principle, and that is this. It is the obligation of the concerned authorities to perform their legal obligation which will prevent this situation. They having failed, we have done only one thing, made them work to perform their legal obligation, and by the method of continuing mandamus, monitored till the obligation is fully performed. Now, so here there is no difficulty. I mean, you see, we have not got down to perform the act, and the kind of orders which the Supreme Court has made has not been, they have not been ad hoc orders. They are based on expert opinion obtained from experts in the field. Now, directive principles of a state policy, you know very well in Part 4 of the Constitution. Now, though they are not mention of or enumeration of a mere pious hope. You see, directive principles require the state to work for raising the level of nutrition for the purpose of improving public health.
Well, let me come to that. You're now sort of heading the National Human Rights Commission, and that has sort of taken a very expansive view of human rights, beyond the mere declaration of human rights in the United Nations Charter. What has again prompted this? Is this an extension of the judicial activism principle into human rights?
You see, judicial activism, just add to what I have said earlier. Actually, in that Manila conference, I ended by saying that the best form of judicial activism is that which ensures that every authority performs its obligation and function so that the need for judicial intervention becomes the least. Now, coming to the human rights. Well, of course, I did say in a lighter vein to someone that it gives me an opportunity to try and complete my unfinished agenda. Of course, the agenda is very long, and there are so many competent people who will carry it forward. But NHRC's role, I consider to be complementary to that of the Supreme Court while I was in the Supreme Court itself. We are actually working in the same field. There are certain things which in the court, for example, I could not do myself, and no court can do because you don't have an investigating wing. You don't have people to investigate.
What are some of the areas that you've initiated that you felt that if you were on the National Human Rights Commission you would do?
Well, I didn't feel trampled for that reason, because in the court I sent those matters requesting the NHRC, National Human Rights Commission, to kindly investigate and give its report, so that on that basis I made orders. Some of those matters, incidentally, which I sent are still there, and so I didn't know that I'll be required to deal with them. So there is absolutely that disability which the court has of being able to ascertain the facts for the purpose of being sure that it was making an order which is appropriate.
Right.
You see, that area is filled by what the NHRC can do and give its report, and what greater assurance can the Supreme Court have when the NHRC, so constituted, gives its report. I never had any difficulty when I was in the court, and I'm sure those who are there now will feel similarly.
You know, India has been sort of uncomfortable with the notion of a universal declaration of human rights, and has been sort of suggesting, along with China and some other countries, that human rights are culture specific and there should be a larger view of this. For someone who's, with a legal background and working, even if creatively, with the law, how do you respond to this position?
Well, my response would be this. In the first place, I don't think the government of India is uncomfortable with the United Nations Charter or any of these other international conventions. And apart from that, while in the court itself, it was settled, and incidentally, that was my decision first in Nilavati, Behra, and then Vishaka, where we said that international conventions and norms, to the extent they are not inconsistent with the domestic law, or in the area of vacuum, they can be used as a canon of construction of the domestic law for the purpose of expanding the meaning and scope of the domestic law wherever that's the requirement. That's the exercise I did, you see, in Vishaka. You see, in Vishaka, where we defined sexual harassment, relying on CEDAW and other Beijing principles, etc. That's what we did. So I don't think India is at all uncomfortable, and at least in the court I didn't feel so. Net result is, international conventions, whether signed or ratified or not, if they are consistent, or if I may say so, not inconsistent with the domestic law, then they can be read in, and that's what we have done, reading them into the fundamental rights already guaranteed in Part 3 of the Constitution. That's how Article 21 has been expanded so much, Article 19, 14, all these.
You had a sort of an unimpeachable reputation as a Chief Justice, but the legal tradition, the legal profession, the legal processes in India are severely tarnished, and few people, if any, have faith that, and we discussed justice, that justice would be delivered, and certainly not delivered in time. How have you sort of struggled with this in your own career and trying to improve this, change this?
Well, I mean, what you say is certainly a very significant aspect which has got to be dealt with more effectively by the judiciary, and because if merely saying that a speedy justice is within Article 21 is not enough, unless we translate it into action and really also give a speedy justice. Now, there are so many factors which contribute to the huge backlog. There's no time and no occasion to enumerate all of them. But what I'll say is, I have been convinced always, with the available strength of judges, with the available infrastructure also, of course, a lot needs to be improved, no doubt about it. Much more can be achieved, and my own perception is that the artificial areas, that's the expression I used first in 1985 when I was Chief Justice in Madhya Pradesh, to describe those cases which are either frivolous litigation or which just need to be taken up and they'll hardly need any time to dispose of. Now, at that time I had said there are about 25 to 30%. Now I think in some courts it might be as much as even 50%. And this experiment succeeded in the Supreme Court. In the Supreme Court, may I tell you, you see, in 1989 when I came to the court, we were hearing for the first time special leave petitions filed in 1973-74, that's 15-16 years earlier. Then of course everyone felt, And some Chief Justices who were there, they also felt and they were persuaded by some of us that this could be improved. So from 91, 92, a serious attempt started. Of course, the effort was on. It was accelerated. Just to give you a bird's eye view, on 1/1/92, I'm giving you figures from memory. They may not be wholly accurate, but they would be approximate. On 1/1/92, the areas in the Supreme Court were more than 120,000. Now, that's when the computerization was started. I must give credit to Chief Justice Kania, who picked up and entrusted the task of managing the registry to Chief Justice Venkat Chalaya, who was later to succeed him. Now that effort continued. Everyone in the court, including the registry, I mean, the lawyers also cooperated. And you see, we were able to collect cases, club them, do that. And when Chief Justice Venkat Chalaya retired on 24th of October 1994, the areas had come down to less than 55,000. When Chief Justice Ahmadi retired, because this was a continuing process. When Chief Justice Ahmadi retired, you see, and I took over in 97, at that time the areas were 23,000. When about some 2-3 weeks before I demitted office in January 1998, the areas had come down to 19,019. And the annual filing during all this period, minimum was 25,000. 1 year it went to 49,000. And the average would be around 35,000 or so. So less than a year's, much less than a year's pendency. And that along with, you see, the cases which are termed as judicial activism going on. So, and mind you, the strength of Supreme Court, you see, was hardly ever full.
But do you think these principles are actually applicable and workable down the judicial system? Because for most people, justice is not sort of, you don't reach the Supreme Court to get justice.
That is what we had been trying to impress. You see, somehow it so happens that conditions in the high courts were not as bad, at least the time when I was in the high court. Now what I hear, high courts are pivotal in the administration of justice. They have not only to keep their house in order, they are also entrusted with the power of control over the subordinate judiciary under Article 235. You see, and well, somehow.
What about corruption? You have spoken out against this, and surely the judiciary reflects the community, the society, and it's a part of everyday life. But it has a special significance when it impacts the judiciary.
You see, I think you have also answered your question in your formulation. You see, if people are drawn from the same society and there is some serious aberration in the society, then you see no one branch can remain totally immune. The only thing is, comparatively, undoubtedly, things are much better here, more because of traditions, peer pressure, and you see, traditions I think matter quite a lot. But well, I have always been for, you see, having an effective mechanism for enforcement of judicial accountability. And for that reason, you see, the process was started in 1993. In the Chief Justice's conference, a resolution was passed. Then, you see, Chief Justice Venkat Chalaya, you say, he constituted a committee in which I was also there, to Supreme Court judges, to Chief Justice of High Court, which drafted some what is now known as restatement of values. But somehow that couldn't get finalized and formalized. So when I took over as Chief Justice, see, that thing was again put into motion. And on the 7th May, 1997, see, during my time, what you have now read was already unanimously adopted by the Supreme Court. That along with another resolution to declare the assets and also for an in-house mechanism. And you see, I and the other judges of the Supreme Court, you see, they made their declarations, they were there. And then of course, I was conscious all along that this does not have any legal sanction. It will depend on the consent of the judge concerned if something has to be done. And therefore, on the 1st of December 1997, about 2 months before I demitted office, I wrote to the Prime Minister, in which I wrote all this, sent him all what was done, said that this is all which could have been done by us from inside.
Without legislation.
Without legislation. And I personally feel that legal sanction ought to be provided. This is the framework on which you could work. Now, thereafter I demitted office. I think others are following.
In this sort of relationship of judicial activism, reaching out and looking at concerns of the community beyond merely law, public interest litigation has played a very important role. And we were talking about the National Human Rights Commission and how it has taken a very large, expansive view of human rights, looking at issues such as environment and even something as specific as iron deficiency, anemia.
Yes.
What has prompted this, and what are the limits to?
Well, limit, if you ask me, would be when every individual, every citizen of the country has, you see, got the means and is in a position to live with the dignity which is due to every individual, irrespective of the circumstances of his birth or his station in life. You see, of course, there would be some variation depending on, you see, your means. But the basic minimum which is required for life with dignity, unless that happens, and that's a far cry. And talking of human rights and the wide expanse, I'll tell you only this. My understanding of the meaning of human rights does not depend on the definition in the Protection of Human Rights, Protection of Human Rights Act 1993 or any international convention. It's something more basic and fundamental. The preamble to the Constitution assures the dignity of the individual. That's the constitutional promise. And therefore, every characteristic or attribute required for human existence with dignity of the individual is a human right. And the test to find out what is there, what is in it and what is not, ask yourself the question, what is that which you would consider to be consistent with your own dignity and therefore it must be had, and what is that which you don't need for a life with dignity? I think that's the surest and safest test to apply.
Thank you very much, sir. That's been a great privilege.